Ernie Hall. Pete Peterson.
Elvie Gray Jackson.
Tim Steele.
Bill Falsey.
Julia Tucker, Assembly Council.
Thank you. I'd like to begin the work session with some comments from Mr. Evans because it is his ordinance that was brought forward initially. Mr. Evans, you have the floor.
Madam Chair.
Mr. Bosky, I'm sorry.
That's okay. I just want to start on the record that I'm here.
Thank you. Mr. Bosky is joining us by phone. Thank you, Mr. Bosky. Mr. Evans.
Thank you, Madam Chair. What I'll probably do is just sort of begin by sort of an overview of what's trying to be accomplished here. Give you some of my perspectives on more or less why I brought this forward. We can discuss some of the details in it. Obviously, it's changed since its beginning. Everybody should have an S-1 version in front of them, which is the latest iteration of the saga. But to start with, I do want to make some general comments about what the goal of this was. I think it's important for everybody to understand when we're talking about equal rights ordinances that everyone in this room is currently covered by the equal rights statute. Everyone has a race, everyone has a sex, everyone is either married or unmarried, everyone has an age. Everyone in Anchorage is currently covered by equal rights protections. There's not groups outside of it. Everybody is covered. So when we add categories, as we're doing here by adding sexual orientation and gender identity, we are not adding people to coverage. We're not adding anybody that already wasn't covered to the coverage of the acts. What we're doing is adding ideas. And the ideas we're adding are what we consider appropriate or inappropriate in our community. And in this case, in the ordinance 96 that was put forward, the idea that we're putting forward is that in Anchorage, Alaska, in the 21st century, the notion that people would be discriminated against based upon their intrinsic view of who they are or who they choose to love is unacceptable. And that is the bottom line reason for the ordinance. Now, it gets a little more complicated. There's another idea involved in that was important to me because obviously when we talk about issues like this, when we talk about sexual orientation, gender identity issues, they're issues that are very emotional to people across the community. They've engendered a lot of inflammatory conduct, inflammatory actions over the course of the discussions, over the course of the years. And often, that debate can be very negative for a community, can be very hurtful for individuals. So part of the reason I chose to bring this up was because I had an idea that how we go about adding this idea to our community is as important in the long run as the specifics of the language in the ordinance itself. Because at the end of the day, most of the problems you see around the country that involve these kind of issues stem, at least in my opinion, from people being unwilling to make it work, being entrenched in sort of views that it's a zero-sum game and either my side wins or your side wins. People being unwilling to make a good faith effort to incorporate different ideas and people different than themselves into daily life. So it seems to me that the process by which we go about changing the law to add this idea, if the process could reflect the ability of the community to address a topic that is divisive, that is controversial, that is emotional and passionate for some people, but if we could do it in a manner in which we show respect for others, that we show civility in how we handle these issues, I think hope that in the long run, it makes those difficulties and those problems that tend to arise less likely. Accordingly, when I drafted the original the original ordinance, which was without an audience, it was just, Mr. Falsey was involved, but it was just most of the two of us. The idea was not to necessarily, although it's been characterized a number of different ways, it wasn't to provide a limited form of equality or to provide opportunities for people to discriminate. It was designed to recognize at the outset that there were various ideas and various concerns in the community, some of which are legitimate. I mean, there's illegitimate concerns, and there's people who want to be discriminatory and be hateful, and it's not addressed towards that. But there are people who don't understand necessarily how this works out, or have concerns, about how it would play out. And I tried to address those concerns that I was aware of in the ordinance, so that when we had the discussion and moved this forward, it would be from a position of sort of inclusion. It was a perhaps failed attempt to try to bridge some of the seemingly unbridgeable chasms in our body politic. That being said, it included provisions that allowed for religious exemptions for people of religious convictions to not necessarily have to do certain things. I think the exemptions were much narrower than they were portrayed to be and that people were concerned about, but they did exist. It also provided some protections for employers who would be sort of the principal front line of incorporating these new ideas, and brought all those groups together, I think, in one ordinance. Over time, and I put that out there, and since then I've talked to groups on both sides of the issue. Nobody liked it. It may have been almost perfect in its ability to generate unpopularity in all fronts, and maybe that way it was almost magic. But a lot of people. I mean, I wasn't expecting to be applauded for it. I expected there to be opposition. And everybody has been, very understanding of that. Mr. Flynn has put forward an S version of my original that tried to keep it more narrowed to expanding the rights under the equal protection laws and eliminating some of the other protections that I put in the original ordinance. And then faced with that, just recently, Mr. Flynn and I got together to try to discuss basically what the interests were here, because the goal is to, like I said, I think both Mr. Flynn and I have the same ultimate goal, is to make that statement about what is acceptable in our community in this day and age, and how we get there. So we came up with the S-1 version, which kind of combines some of the original ideas in my version, but also that were modified by Mr. Flynn to address concerns by other groups. And those concerns are legitimate. As much as I like the notion of us, having a kumbaya moment and being able to say, yes, we can extend these provisions, and at the same time, anybody who has, religious concerns will be protected. At the end of the day, it's a very fine line to walk. There was the possibility in my language that people who maybe don't intend the same goodwill that I intend when I put it out there, to abuse it. The religious conscience exemption was probably the most concerning to people. It allowed basically persons not to be forced to go to ceremonies or rituals that their own personal religious conscience objected to. It was an attempt to address all the bakers and the photographers and all these cases nationwide that you've been seeing in the press. But there was concern that that could be misused by people to cause rampant discrimination. And it wasn't limited to same-sex weddings. It was across the board. So even if it was an interracial wedding or any ritual that involved some type of ceremony, ritual or ceremony, people would have that opt-out. And a lot of people viewed that as too broad. I think it could have worked, but I understand it was new and novel and caused more concern than it was probably worth. So that exemption was eliminated from the S-1 version. It's no longer part of what's being put forward. There's still religious exemptions. There's always been religious exemptions in our Equal Rights Act. We did tinker with those somewhat. There's a ministerial exemption that has been the source of a tug of war as to how broad or how narrow that is to be. Mr. Flynn and I came up with some language, but even with that, there are groups on both sides that would like to broaden it and like to narrow it. So, we'll see how that goes. But that is the basic of what we put forward, and I can go into the details. It's really not a very complicated ordinance. It's 12 pages or whatever it is. Most of it are just language changes in various places that add the terms sexual orientation and gender identity to the existing statute. There are some difficulties we have tried to address. Spent an inordinate amount of time in various meetings talking about bathrooms. Because when you're talking about some of these issues, it's unfortunately just an area that involves privacy, and people want to talk about bathrooms and locker rooms, and we did our best to identify the issue to allow employers or persons operating locker rooms or bathrooms to have the flexibility to deal with it in their own way, while at the same time ensuring that people would be protected in their ability to use the facilities consistent with their gender identity. Is it perfect? No. Can there be problems down the road that, wild situations that people try to take advantage of this? Absolutely. But if anybody has better language or better way of addressing that issue to prohibit and prevent any future conduct of people trying to take advantage of the law, I'm all ears. We just came up with the best language we could to do. It's not perfect, and like I said, there's enough people upset about it that we're probably close to having the right answer. And with that, I appreciate Mr. Flynn working with him on this. I think that's consistent with what I wanted to do in the first place, is to make this an issue that is not necessarily partisan. It's not necessarily a conservative or liberal issue. I think there's elements of both in this. But the most important thing for me is how we do it. And I think we have a start. I think Tuesday night we'll see how that goes and how this body reacts. But I'm hopeful that we can get this passed and in some form. I still I still have this idealistic notion about my original form, but I realize it didn't generate a lot of support other than me and my family. They kind of liked it. But it is what it is, and I turn it over to Mr. Flynn for his take.
One moment, please. Thank you, Mr. Evans. And before you start, Mr. Flynn, Mr. Haberman, you're not a reporter with a camera, which would cause you reason to stand up. So would you mind having a seat in the audience? It would be a little.
I'm going to be close so I can hear what you're saying. And I'm not in anyone's way over here. Sure.
There's a chair. I just really would appreciate it if you.
I've been doing this for 4 years.
Okay, thank you. Mr. Flynn?
Thank you, Madam Chair.
You're welcome.
I guess I don't have a lot to say other than first, my thanks to Mr. Evans. You and I, Madam Chair, have been through this before. This is an enormously challenging topic. Mr. Evans has yielded to work and being respectful of a variety of viewpoints. And activities is our primary function. Because we have too many other things we have to do. So in the S version, we went to substantial. In this final version, we're at include. So that's the broadest of the three versions in terms of the ministerial exception. And I expect we're going to have some dialogue next week on whether include is more appropriate or substantial is more appropriate, or if there's a different term that's more appropriate. I'm open to that dialogue. I think it's worthwhile to have. We do want to be respectful that if you are a teacher at a faith-based school, for example, most of your day is just lay education. But you also have responsibilities based upon the faith, that there'd be an expectation to be respectful when you're a member of that faith. I think that's reasonable. So we just sort of need to figure out if we have the right term in there. And with that, again, I offer my thanks to Mr. Evans. You showed great courage in bringing this issue forward. This was very good to work with. We haven't always agreed. We've argued a little bit. But I'm proud of his efforts and appreciate him reaching out to me more about this.
Thank you, Mr. Flynn. Mr. Hall?
Yes, thank you, Madam Chair. Mr. Evans, I don't know if you've ever argued cases in court, but if you do, I'd like to get a notice of that. I would love to go sit and listen to you argue a case. The way you weave brevity in it is just fantastic. I originally had actually wanted the co-sponsor with Mr. Evans, but he really wanted to bring this forward himself, so I had my name added at the first meeting. Because I knew at that point in time, Mr. Evans has always shared with me that once they had this drafted, he was certainly going to be open to discussion and trying to make sure that we found an ordinance that was going to do, hopefully, the best we possibly could do for this community on this particular topic. And ladies and gentlemen, to me, this is how government is supposed to work. I mean, in an ideal world, if we could just see the federal government do this and our state government do this, this would be such a better environment that we all live in that it would be absolutely unbelievable. But my hat off to both of you, Mr. Evans, for the job that you did drafting the original, and Mr. Flynn, your work on finding the compromise language. It made my day this morning when I opened the paper and saw that there was an S version coming forward. It's going to make for a much more pleasant meeting on Tuesday night because of all the work you've done. And I can't thank you enough because this is long overdue for our community. Thank you, Madam Chair.
Thank you, Mr. Hall. Mr. Peterson, do you have any comments?
Well, thank you, Madam Chair. And I just want to thank both of my colleagues for their work in bringing this forward. I'm not sure why Mr. Evans decided to walk out on the plank, but I think the product we have here is a step in the right direction, and hopefully we'll be able to find a way to agree and get this passed and move our community forward. Thank you.
Thank you, Mr. Peterson. Do you have any comments, Mr. Joe?
I'm just thankful you guys did bring it forward. It was long overdue. It was I was not on the body last time this came through, and
Lucky.
it was good because I was able to go to sleep. But that process kind of showed us how sensitive the issues were at that time. We've come a long way, I think, as a society since then. But the two of you, Mr. Flynn and Mr. Evans, working together on this, I think have done yeoman's work, and I think it's ready for prime time. So, thank you.
Thank you, Mr. Steele. Mr. Mbosky? He's not there. Right. I just have one really brief comment. And first,
Madam Chair, I don't have anything right now.
Thank you, Ms. Zimbowski. I want to thank Mr. Evans for bringing forward, for beginning the discussion once again, because I was, as Mr. Flynn already mentioned, I was there for the 4 months that we dealt with this issue before, and the last time also. So thank you, Mr. Evans, and thank you, Mr. Flynn, both of you for working together to try and come up with a document that we can get a lot of support from our colleagues to move on in this community and just simply do what is right for everybody in our community. And with that said, if nobody has any issues with what I'm going to suggest right now, since we have a whole hour left, and we have a big audience, and I would like to provide opportunity for some comments from the audience, and if anybody has any issue with that, tell me now. Is that okay? Does anybody have an issue? Because that is what I want to do, and I'm about to do it. So, thank you. If you want to make some comments, please just raise your hand, and we'll take one person at a time. Caitlin, yeah, please. Can you stand up and speak loud, please? Thank you.
My name is Caitlin Shortell. I'm a lawyer, and I've been really interested in protection of civil rights in Anchorage and Alaska. And I actually prepared a memo after looking at the S-1 version. I'm really pleased that the Assembly members are working together to try to come up with a compromise. And I think that the S-1 version that you've come up with addresses a lot of the concerns that we had about the original version. At this point, my recommendation would be to edit the ministerial exception, probably along the lines, I'm sure that this conversation has been, as you said, going back and forth about whether to broaden or narrow the exception. And I think that my recommendations that I've put together in a brief memo that I'll give the Assembly members aim to just make sure that we're not opening the door to discrimination by the proposed language in the ministerial exception, and also refer to a recent Supreme Court case in 2012 that dealt with this very issue to try to look at how we could just make sure that we can reasonably limit the ministerial exception so as not to lead to or enable future discrimination. So that is my main concern and recommendation, and if with your permission, I'll just make this available to the Assembly members.
Thank you. What you can do is give it to Barbara Jones, our municipal clerk, and she'll make sure that we get a copy. And thank you for your comments.
Thank you.
You're welcome. Anyone else like to make some comments? Now's your opportunity before the public hearing.
LB, Chris Constant here, and instead of coming and talking on Tuesday, I'll be there, but I'll save you 3 minutes. I'll just say one thing. Thank you.
Thank you. Anyone else like to comment or ask a question? Okay, well, thank you everybody for, Mr. Clary.
Yes, Madam Chair, thank you for a moment.
You're welcome.
To speak to everybody. In reading the two versions, I prefer the original version over the substitute version. And I'll give you some of my reasons. First of all, last time that we dealt with this, the Equal Rights Commission was tasked with the responsibility of bringing to the Assembly empirical proof that this discrimination in this town exists to these groups. However, I am in favor of Mr. Evans' draft and his proposal, but not the substitute. Like on page 2, you take out the sincerely held phraseology for those who are people of faith, but give it to those who have a different gender identity, and put it in this clause right here in the middle of the page. And I often wonder, as I read this, as it says, not being asserted for an improper purpose, who makes the determination of what an improper purpose is? And I would ask maybe Mr. Flynn to address that and make some clarifications on that phrase, because that phrase to me could be a trip-up phrase and a very difficult phrase for some in our community. The second thing, of course, is the cross restroom use. I see that as a problematic. However, I think the original version probably gave us the best that we could have in that. And then in taking out the dress codes and changing those, an employer has a responsibility to ask his employees to wear certain uniforms and something like that, but the way that it was reworded takes away some of that liberty and freedom that an employer or an owner of a business has. On the 10th page, I'm really concerned about C being extracted from this, and I would ask for reinstatement of that by this group. And if you notice on the last statement here, it says the sincerely held and demonstrable religious beliefs of that person, employer or operator. That's the phrase that I'm talking about that was extracted from people of faith and given to this special rights group that we're formulating here. And I would say that these things need to be considered. I think the first draft is better than the substitute draft, and I'll be there Tuesday night to give some more information to you.
Thank you, Mr. Clary. Anyone else? Ms. Jones?
Could you please identify yourself for the record?
My name is Glenn Clary.
Okay, thank you very much.
Thank you, Madam Clerk. Anyone else? Okay, any other comments from my colleagues? Mr. Evans?
I just wanted to make sure that credit's due or blame gets put out there. I did receive a lot of assistance from Mr. Falsey in drafting the original. Bill and I had worked together previously as partners, but around the same time this was going on, he got the job as the community law director. So we already had a personal relationship. It was easy to work together. He was a good partner in trying to put into language what I was trying to get at, and it was very helpful. A lot of the language, whether you loved it or hated, was Bill's. And then Ms. Tucker did the most recent assistance with Mr. Flynn and I's S version, and got this S-1 version together, so they should be recognized for their role as well.
Thank you, Mr. Evans. Mr. Flynn, you look like you have something to say. Okay, great. Well, with that said, thank you everybody for being here. The meeting is adjourned.